Broadly speaking, there are 5 main ways in which a will can be challenged. The first is where the will fails to meet the legal formalities as set out in the Wills Act of 1837. Section 9 of that Act confirms that a will must be in writing, signed by the testator, i.e. the person making the will, and that signature must be made or acknowledged in the presence of 2 witnesses present at the same time. Those witnesses must then sign the will in the presence of the testator. The second ground is where a testator lacks what is known as testamentary capacity. In short, for a person to make a valid will, they must be of sound mind. The test for that is laid out in the 1870 case of Banks and Goodfellow, which, to paraphrase, confirms that a testator must A. understand they're making a will and its effect, B. know the nature and the value of their estate, C. understand the consequences of including and excluding certain people, and D. not be suffering from any disorder of the mind which may influence their views. The third ground is lack of knowledge and approval of the content of a will. Even if a will appears to be validly executed and the testator had mental capacity, if it can be shown that the testator was not aware of its contents or there were suspicious circumstances, then this may lead to the will being invalid. The fourth ground is where a person has been unduly influenced into making a will. Mere persuasion of itself is not unlawful, but pressure which overpowers the free will of a person can lead to a will being set aside. One particular form of undue influence is fraudulent calumny, which is where a person influences another to exclude certain people from the will on the basis of false allegations. Leading on from fraudulent calumny, if a will or any part of it was procured by reason of fraud, then that will be invalid. A will can also be set aside if all or any part of it was forged. For example, a common ground is where the signature has been forged. In that case, the whole will obviously be invalid, and it could also lead to criminal convictions. These are the main grounds, although there are other options which can be explored, such as firstly, arguing that the document is not in fact a will. Secondly, arguing that it's been revoked by a later will or subsequent action. Thirdly, arguing that a person is prevented from leaving certain assets in their will due to a prior agreement. Or finally, interpreting the true meaning of a will where it's ambiguous.